Did you want to talk?
Yeah, Judge, I've got a case, Derek Adams, on the docket. He was supposed to complete 2 classes by today.
Not do it?
No, he did. But he didn't pass one of them. And the contract doesn't require passing.
Okay, pause. So Derek took the class but failed it. And here's the kicker. The contract doesn't require him to pass, just attend. Think about that. Should someone get a pass just for showing up? Let me know in the comments. Do you think effort should outweigh results in court-ordered programs?
It requires taking, and so Miss Saba, hey,
Judge,
contracts.
I just needed chief approval that's sufficient. I've never been in this situation. Like, I don't know if I can dismiss a case for failing an effective decision-making course, but attempting it.
This judge, there's not a single chief working today. It seems like there's not really effective.
So let's roll it to tomorrow, have him take it again.
I'm not coming back here.
Zoom in. That's why I have Zoom, to make it easier for you.
That's true.
No.
I'm appointed. Money's really tight for him. The
case is 1,292 days old. We've given him how much grace to get this thing done over and over. Really.
And it was just 2 classes, Judge.
Last time, if you didn't have it done, you didn't have it passed. I'm carrying you day for day.
The contract doesn't require passing. I mean, I'm actually serious about that. Although it's funny.
Whoa, this case is over 1,290 days old. That's more than 3 years of back and forth. At what point does grace turn into delay? Judges are human too, and you can feel the frustration simmering here.
I would be hard-pressed to find a chief that's going to acquiesce to that. I mean, really. I don't know.
It was a pretty good PTI offer, Judge. It was just effective decision-making and a gun safety class, both of which are 2 hours. The effective
it's a 2-hour class, right?
Costs $22, I believe. There's no reason he shouldn't be able to do it again.
Just, a lot of times they don't take it seriously. So let's roll it to tomorrow, have him do it again, and then let him know we're going to redo it day for day until he gets it done. At nearly 1,300 days.
Day-for-day consequences are no joke. The judge is basically saying if you don't pass, we'll just keep doing this again and again. This is a major turning point. It signals that leniency is about to run out.
I have no sympathy for this person.
What's the term? A collateral estoppel or something like breach of contract? It's not my bag of chips.
Remember, they're the ones that have the power to dismiss. I don't.
Right.
They're the ones, I just sign it. They're the ones who actually file the motion.
I know that.
So do we know when is she coming back?
I mean, Kelsey won't be back till Monday, Judge.
Okay, so let's roll it to tomorrow.
Yeah.
Have him take it again. Maybe he'll pass it this time. Tell him to pay closer attention. It's only 2 hours. It's not much. If he doesn't want to do it, okay, I'm just going to roll it to Monday. And I'm going to keep doing it. It's 1,300 days. We got to take care of this.
As long as I have a chief tell me that the attempt is fine, like I just can't make that call, Judge.
Did you see how good of an attempt it was?
He failed it. It was like a 50%.
Somewhere around 57.
I'm rolling it to tomorrow.
Okay.
Is there a possibility that we're going to have a chief?
No.
As long as there's another
one
chief.
But if he passes, it gets dismissed.
Yeah. And I can ask another, if our bureau chief is here or one of our deputy dogs, I can go ask them after docket, Judge.
It's up to you.
Oh, I've been around everywhere. There's no chiefs.
Well, I mean, they would be on the 5th floor, Judge.
Yeah. Well, regardless, I mean, we have a lot of work to do. We have 3 other courts that we need to cover as well.
Yeah.
So have him try it again tomorrow. If he doesn't want to do it, then we're just going to roll it to Monday. Yeah, really.
Is Diane here?
He's here, yes.
Adams?
Come on up.
Interesting twist here, the DA isn't present. But negotiations are still moving forward. This part shows how fluid plea deals can be, and how much hinges on communication between the parties. Ever seen a deal fall apart because someone wasn't available?
How you doing?
Hi, Joe.
Hi, Judge. Nice to see you.
Merry Christmas, sir.
Merry Christmas to you, Your Honor.
What are you doing with your client?
Yes, sir. I did talk to him about the most recent offer that came in this morning. The VA's not here, so I can't really respond back to her with some evidence, so we were going to go on.
Judge, she emailed me this morning. She's looked at the mitigation packet that defense sent, and she emailed me this morning telling me what her offer is. So everything that I relayed to her is her latest update.
What is the offer?
It's a 9-month deferred, Judge.
Yeah, and Your Honor, one of the things is, just from reviewing this, it doesn't appear that the mitigation made clear enough, or they didn't take very serious with the statement that the house that the complainant and her mother's living in right now is owned by my client. He's the owner of that house. And they are living there because he's allowing them to live there. Now, he's charged them before, but he has not moved to evict them. He wants this process to end. But somehow, from the notes that we're reading,
What's your client's name? What is your
Ludlow,
Hudlow.
H-U-G-L-O-W.
Yeah.
And
The problem is that it's really old.
Your Honor, and I discussed that with them, and so they're willing to keep. He wanted to talk to Mr. Garza directly. I've been back there calling for the last 30 minutes, if not longer, trying to
I
reach
mean, what we
him.
can do is I can give you till Monday, but it's plea or trial on that day. You know?
That'll be-
Mr. Hudlow, come up.
And Judge, the state's offer is gonna stand. I mean,
Listen closely, this is classic judge wisdom life. Doesn't always go the way you want, and court isn't any different. This message hits harder because it's aimed at both the client and anyone watching who thinks court is about wishful thinking.
All right. Good morning, Mr. Hudlow.
Morning. Merry
You
Christmas.
got to understand reasonable minds can differ. Just because you want something a certain way doesn't mean that it's going to happen. In life, it goes like that in every aspect. You know, when you're buying a car, when you're buying a house, whatever it may be. You know, he can't control the offers that they're going to give. He can only tell them merely what, you know, he is given a certain set of facts and he has to work with those facts. Sometimes they're good facts, sometimes they're not so very good, but it is what it is. Now, our case is old. It's 210 days old, and we set cases for trial at 180 days, and I have no idea how this got to be as old as it is now, but it's time to make a decision. Now, your case, they have offered you a 9-month deferred, which is a type of probation that if you successfully complete, you do not end up with a conviction on your record. You can't tell people it was dismissed because it's not dismissed. It's merely a probation that you took. If you complete successfully, you don't end up with a conviction, right? But that's the offer that they've made for you, and it appears as what the state has said, that it's going to stand. Look,
We're happy with that, Your Honor. Oh, I'm sorry.
you don't have to make a decision today. If you want to make a decision today and you want to be done with it today, we can do that. But I can give you one final setting to Monday if there's other people that you want to talk to. It's up to you. But it's time to put this baby to bed once and for all. So I will give you the opportunity now to talk to Joe to see if that's something that you want to accept now. If you need a little bit more time, I can give you until Monday. But at that point, you must either accept the plea bargain agreement or I'm going to set your case for trial because it's just too old.
I haven't had a chance to talk to Eric. Can we set it for Monday?
Okay?
I'm not saying that, you know.
No, look,
Actually, I would go
you
with-
don't have to say anything.
Okay.
I'm happy to do that. But you get no more resets after that day.
I appreciate
So
that.
if you're unable to get a hold of him or whatnot, I don't care. You need to be diligent in getting together with Eric to figure out what you guys want to do with the game plan. Take a look at all the evidence, and then you make an informed decision at that point. But there's just no more time after that. All right?
Yes, sir. Yes, sir.
And I'm sure that Joe can try to get you, help you get with Mr. Garza. Okay?
Because I don't know with his vacation schedule, you know, I don't want to put anybody out, but that's kind of how I think we ended up here.
We have too much.
Thank you, sir.
Thank you. All right, guys. Good luck.
Thank
you, Joe.
Thank you very much.
You ready?
I'm ready.
All right, come on.
Is there a Vander's license?
So this is it's without me reading, right?
Yes, I told him to put it up there,
Okay.
and these are the enhancements, 6 abandoned those two that you're to the bottom. Just the, there was nothing like he did.
So
Mr. Judge,
but he had an open container of alcohol in the car too, though?
Yes, the surveillance shows that he hadn't been driving from 8:15 to 11 p.m. and the car was also smoking at the time they.
Tell me what happened in this case, because I don't know anything about it.
I can.
I mean, if defense.
No, but I want,
Okay.
please, read to me the dibs.
Hey, Judge. My computer's been slow today, so my apologies.
It's okay. I want to know that I'm making the right decision. Mr. Vanderslice, I take,
This is getting serious. ADWI case, open container. Prior convictions, including a murder and now alcohol found in the car, you can feel the weight of public safety concerns stacking up. The judge's tone shifts, and for good reason.
public safety extremely serious. I don't care who you are. I don't care what color you are. I don't care if you're a small farm animal. My only concern is public safety, you know, and if you leave a wake of death, that's just not a good thing, you know, and now you've got a DWI. They're saying that there's a prior DWI. You've got alcohol in the car as well. I mean, when do we say when? Now, I don't know specifically what happened in your car. I'm just looking at the allegation here.
Prior to DWI, the judgment on DIMS
So,
or
one of-
NCIC is incorrect.
Well, one of them was reduced to a reckless judge, and the other one in Dallas was dismissed because he was convicted of murder.
So
And
this
that
is, it's a third DWI.
It was, yeah, the other one was unrelated.
Go ahead.
On June 7th, 2024, officers were dispatched to the Circle K parking lot where they were advised of a white GMC Sierra. The officer observed the car partially in a stall, and the defendant was the driver and lone occupant passed out behind the wheel. The car was running and the defendant had his foot on the accelerator. The vehicle was in park. The officers woke the driver, who was extremely slow and lethargic, had slurred speech, watery eyes, a strong odor of alcoholic beverage, an unsteady gait, and had to be guided back to the patrol vehicle. 2 bottles of Crown Royal Apple Whiskey were located in the car. One was empty and one had a little bit left. The defendant said, "I'm not going to do anything to incriminate myself" when asked to do SFSTs. The DICs were read and a search warrant was executed and blood was drawn.
There should be an additional part to the probable cause that talks about the surveillance now. But
I'm going to give you opportunity to say your piece, but so initially with this case, you went up and they had offered 270 days in jail.
365.
It was 365, and the reason is because you have a murder case. There was a prior murder case. Did you do time in TDC because of it?
Yes, sir, I did. I did 6.5 years on a 10, and they let me out for good behavior.
Okay,
my-
no, that's, and then not only that, but we have 2 prior DWIs as well. One was reduced, one was dismissed pursuant to the plea bargain agreement. So
2010, I think, 27 was the date of the offense, murder, the case that he had. And then that had nothing to do with the DWI.
The DWI
I sent-
was in 2009.
I sent a letter to everybody explaining